without human interface with the use of technology, wherein a centralized NESC, National Electrical Assessment Center, shall be the medium of communication with the SSCs and the department with the use of artificial intelligence. And the Faceless Assessment Scheme is one of the biggest biggest direct tax reforms in India based on the key principles of efficiency, transparency, and accountability. And our speaker today, he is having vast experience in the domain subject, which will cover a range of relevant practical issues. And please make use of today's session. Thank you, and
Thank you, ma'am. Now I request CA Jayan Tuppuluri, Shikasa Chairman of Vijayawada branch, to introduce our speaker.
Thank you, Narayana. So I'm very much privileged to introduce Sir to the gathering over here. So Sir is a designated partner in CNGSN and Associates LLP, Chartered Accountants. Sir is a rank holder in University and CA Inter and commenced his professional practice in the year 1991 and more than 30 years of post-qualification experience in handling direct tax appeals up to the tribunal stage. Heads the tax compliance and litigation practice in his firm. Has represented complex search and seizure cases before Settlement Commission, both including income tax and wealth tax matters. Has represented a number of complicated disputes including transfer pricing, international tax, which were widely reported on various tax journals and websites, including top 100 income tax ruling published by Tax Sutra and CCH. Also briefs senior advocates in tax disputes before High Court and Supreme Court. Handles family settlements too, and also handles arbitration matters and consultancy services to various corporates and multinational companies. He also represents before authorities under PMLA and Black Money Act and Binami Act. He is also a former chairman, Southern Region Chapter, International Fiscal Association, India branch, and former convener for Chennai Chapter of Income Tax Settlement Commission Bar Association, former president of Chennai ITAT Bar Association, and in many other reputed institutes like this. So I take this opportunity to Sir to interact with the audience and continue with the session. Thank you, sir.
Thank you, Jayan. Now I request Ramakrishnan sir to proceed with your presentation, sir.
Good evening, everybody. It's a privilege to be part of Vijayawada chapter's program on faceless assessments today. Friends, as you know, these faceless assessments have become a norm for the day. And going forward, technology-driven assessments would be the basis for most of the legislations and the authorities. This is because it is easy to administer through the faceless scheme, and also there's a transparency, and it is also very efficient, and it also showcases to the world that our India is one of the advanced countries which is going with this faceless assessment schemes. And like any scheme that is introduced in the initial years, we have practical issues because we are accustomed to working in a specific environment and a specific manner. And whenever there is a change, our adaptability to change and for also keeping up with the technology and the technological developments is a challenge. And the people who are able to adapt themselves are more efficient in the practice than people who are not keeping up with the times. So this is one of the challenges which though it started as a e-assessment proceedings initially, and now it has become a complete faceless assessment. I would take you through the scheme, how it operates. So the background and the history is what I would like to start off with. See, the traditional scrutiny assessments under the income tax was only with personal interaction with the department, and there were quite a bit of undesirable practices, and also a kind of fair and transparency would be there if it is there is no, if the interface is removed. That is the basic objective of the scheme, and also to use of technology for going forward in the income tax assessments. In the year 2015, it was initially introduced as a pilot project for 5 cities, Ahmedabad, Bangalore, Chennai, Delhi, and Mumbai. Subsequently, it was enlarged to Kolkata and Pune in 2016. In 2017, a very dynamic application platform was developed called ITBA to carry out various electronic functions electronically, and the option was provided to the assessee to opt out from the e-proceeding in that format. Then in 2018, except for search-related assessments and international tax charges and transfer pricing proceedings in other pending scrutiny assessments can only be conducted through e-proceeding. The scope of e-assessment was extended to all cases where assessment was required to be framed under 143(3) during year 2018, and assessments shall be through e-assessment. That was the initial project. In 2019, notification under 6162 of 2019 dated 12/9/2019 was issued. That is effective 12th September 2019. All assessments were to be faceless. Objective was to bring in efficiency, transparency, and accountability. And a provision was introduced, 144B, as you are all aware, with effect from 1/4/2021. And this 144B has a full-fledged integration of a assessment scheme, which included review and technical units for the assessments to be done. So wherever there were non-adherence to the procedure, there were writ petitions in various high courts, and the scheme is evolving year on year. And the reopened assessments are also were brought with effect from 1/4/22 under the faceless scheme. The faceless scheme assessments are more driven by data and artificial intelligence. And one of the key aspects is abolition of territorial jurisdiction for assessment. And the assessment is allotted on random allocation to assessment units through the system. And centralized issue of notices using the unique document identification number is done through electronic mode. And all responses have to be submitted electronically only. So the functional specification for specific parts of assessments have been made for different specialized units. Only a single point faceless contact between taxpayer and the department. So the process is entirely done by your response being uploaded in the income tax portal, and their queries are also sent through email and uploaded in the portal. So this is how the whole system is operating. And if there is any adverse order, then a draft order shall be provided to the taxpayer for response before finalization of the assessment order. And this scheme entirely is based on a dynamic jurisdiction, where the draft assessment order is done in one city, review is done in one city, and the finalization in a third city. So this is only to see that the tax compliance is done uniformity in application of law. So I will also take you through what are all the possible difficulties that are being faced and which we feel would be avoided or in the evolving and changing environment be addressed in the future. So the scheme is under 143(3)(a), where the section clearly explains that the interface is eliminated and also optimum utilization of resources through economies of scale and functional specialization, and introducing team-based assessment with dynamic jurisdiction. So in this Faceless, you have the assessing officer who would work on the case. The questionnaires are approved by the additional or the range head, and then only it is issued. So it is not a single officer who decides on what is to be done on a particular case. So there is a team-based assessment concept that has been introduced instead of the jurisdictional assessment concept which we had in the past. Then 143(3)(b) is the central government may, for the purpose of giving effect to the scheme, by notification, direct that any of the provisions of the Act relating to assessment of total income or loss shall not apply or shall apply with exceptions and modifications. And the modification is that certain cases like search and survey cases and international cases, tax cases and transfer pricing proceedings are taken out of the Faceless scheme. And there are no specific directions after 31st March 2022 in this regard. So the whole scheme, how it operates, is captured in this chart, which there is a central National Faceless Assessment Center, which consists of assessment unit, verification unit, technical unit, and review unit. And these units are at each regional level. The regional level units would report to the national unit. And this is how this scheme has been designed. And it has got a centrally controlled e-assessment or Faceless assessment system. And the central cell will be the interface between the taxpayer and the department. The central cell is located in Delhi and was inaugurated on 7th October. And this central cell is headed by the Principal Chief Commissioner and our Principal Director General. That is the designation of the head. And for each region, the regional Chief Commissioners are there for Faceless assessment team. And they have the power to transfer the case to the jurisdictional assessing officer at any stage with the prior approval of the board. I'll come to this, why this part of the power is given in the subsequent in the presentation. Then the powers and NFAC are illustrated in the following flowchart, which consists of, as I told, assessment unit, verification unit, technical unit, and review unit. And each of these units are headed by additional commissioners or joint commissioners, ably assisted by the deputy commissioners and assistant commissioners and ITOs. And to assist them, you have the ministerial staff and the inspectors as are considered required by the CBDT. And all communications between all the units for the purpose of making an assessment would be through the National Faceless Assessment Center. Identification of points or issues of material for determination, including the refund, is what this assessment unit is required. Seeking information, clarification on points or issues so identified. Analysis of the material furnished by the assessee or any other person, because they have powers under 133(6) to call for information from any other person also. And such other functions that are required for making an assessment, which all of us are aware, which are there for the erstwhile scrutiny assessments which were conducted in person, and the preparation of the draft assessment order. These are the functions of the assessment unit. The verification unit functions are inquiry, cross verification, examination of books of accounts, examination of witnesses and recording of statements. And these are the predominantly these functions. And apart from the above functions, the above functions are also to be carried on by video conferencing. And apart from these functions, any other functions that are required to perform the above functions are also carried out by the verification unit. Then the technical unit is for providing any kind of technical assistance on all the following aspects: the legal aspects, on the case laws relied on or interpretation of the provision, accounting aspects, in case of any forensic material that are required, examination that is required, it is carried out by the technical unit. Then anything related to information technology, valuation, audit, transfer pricing, data analytics, management, or any other technical matter, the technical unit is only to be sought by the assessment unit, and they would provide the technical assistance in this regard. So, as I had said earlier, section 144B is a self-contained code which defines the procedure. Subsection 1 says what is the procedure, which should be as under. Subsection 2 says certain class or class of people, the faceless assessment would be applicable and they would be specified by the board. Subsection 3 says who all have the jurisdiction, what is the functions of the National Assessment Center, assessment units, verification units, technical units, and review units. And subsection 4 defines the authorities of each of these units. Section 5 and 6 defines the communication and delivery. Subsection 7 is the section which grants powers for special audit wherever required, which is also there under 142(2)(a). So subsection 8 is where at any stage the powers of transfer of the case to the jurisdictional assessing officer, because the concept of jurisdictional assessing officer is still there, but the jurisdictional assessing officer will not carry out any assessment functions. So that is the only difference. Subsection 9 and 10, which were there erstwhile, prescribed that if if there is any violation in the procedure, then the order passed would become void. And this subsections were omitted by Finance Act 22 with effect from 1421 and 1422 respectively, because these two subsections were the reasons for quite a bit of litigation in the courts. Wherever the process was not followed, the orders were challenged by the taxpayers before the high courts in the writ jurisdiction, and the courts held the assessment orders to be void. And the department felt that since it doesn't have any recourse, and to avoid this kind of litigation, it omitted these two sections. And in case the procedures are not adhered to, now if a writ petition is filed, the matter is again sent back to the faceless assessment scheme to complete it in accordance with law, thereby curing the procedural lapses committed in the order that has been already passed. The terms defined under the explanation to section 144B are quite important, because the addressee is, you will have to have a registered email, and it would be the address to which all the communication will be addressed to. And authorized representative is as having the same meaning as per 288(2). And the automated allocation system is the algorithm for random allocation of cases using suitable technology tools and artificial intelligence and machine learning. See, what happens in this automated allocation system is there is an algorithm that is prepared so that the cases emanating from a particular state are not allotted to the officers in that state. So that is one of the points in the algorithm, apart from the other points which the algorithm is developed. And this is used for the assignment of cases to different assessment units. Then automated examination tool is again using the artificial intelligence and machine learning, which actually reduces the scope of discretion. Then quite a bit of meanings are assigned from the Information Technology Act, like the computer resource or computer system. The computer resource of the assessee shall include the assessee's registered account in the designated portal of the Income Tax Department, the mobile app linked to the registered mobile number of the assessee, or the registered email address of the assessee with this email service provider. This is very important because all the communications in the faceless system happens only through the emails and by the uploading of data through the portal. And in some cases, you will get an alert in the mobile number. But most of the communications are done only through email. So the email ID of the assessee is quite important for this entire process. Then the digital signature is as defined under the Information Technology Act, because since everything is being done digitally, so the digital signature is also having an important role to play. I'll come to that in the later part of my presentation. Then the designated portal shall be the portal of the National Faceless Assessment Center. And wherever dispute resolution panel, because there are transfer pricing cases, only the transfer pricing proceedings are done in the physical mode, but the final assessment order would be passed only in the faceless assessment system scheme. So the dispute resolution panel has the same meaning assigned as per 144C. And the faceless assessment means the assessment proceedings conducted electronically through the assessee's registered account in the designated portal. So this is again being emphasized that the registered account would be the registered email account. Electronic record again is borrowed from the Information Technology Act, and e-verification code or the electronic verification code is the code generated for the purpose of the whole process of proceedings, because as and when you file the any communication, there is a general e-verification code is generated, which is also quite important for the purposes of documentation. And eligible assessee shall have the same meaning assigned to it in class B of subsection 15 to section 144C. And email or electronic mail or electronic mail message means the message which are transmitted electronically to the through the email account. So there is also another term called this hash function and hash result, which is again borrowed from the Information Technology Act. And the mobile app shall mean the application software of the Income Tax Department developed for mobile devices, which is downloaded and installed on the registered mobile number of the assessee. Then the real-time alert means any communication sent to the assessee by way of SMS on his registered mobile number, or by way of update on his mobile app, or by way of an email at his registered email address, so as to alert him regarding delivery of any electronic communication. So whenever a notice or a questionnaire is sent, it is also followed by a real-time alert through the SMS or through email. Then the registered account, as I said earlier, shall be the registered account in the designated portal, because this is the key through which the entire proceedings are going to be carried out. So therefore, this plays a very important role. And registered email address has a clear definition. So the email address available in the electronic filing account of the addressee in the designated portal, or in the last income tax return, or the permanent PAN database, whatever the email is available, or as per the, because PAN and Aadhaar are now linked. So the one which is in the Aadhaar, if there is not available with the PAN, and if it's a company, whatever is available as per the records of the MCA, official website of the MCA. And the residual clauses, any email address made available by the addressee to the income tax authority or any person authorized by such authority. So this is the residual definition, where if there is any change required in the email address and you have to carry it out in the portal, or you have to intimate the National Faceless Assessment Center. This is playing a quite important role and is also the reason for quite a bit of litigation in the past. Registered mobile number is the mobile number of the assessee or his authorized representative appearing in the user profile of the e-filing account registered by the assessee in the designated portal. So in the e-filing for this thing portal account, you will have to create what is your mobile number and also the mobile number of the authorized representative, so that the communication is not missed out by either of them. Then the video conferencing facility is also defined, that the communication in real time through audio video signals. So subsection 9 and 10, as I said, which created quite a bit of controversy, which said if the procedure is not followed, then it would render the assessment order non-est. That was the erstwhile provision. So this is the overview of the entire assessment process. Is first thing, the case is assigned randomly to any assessment unit by the National Faceless Assessment Unit, and the assessment unit would issue 143.2 or 142.1. Then the next stage is the notice through the NFAC is forwarded to the assessee. Then the assessee has to submit the response within the dates specified in the notice. Then the NFAC would forward the notice to the assessment unit. The assessment unit would ask NFAC to communicate with the assessee verification unit or technical unit wherever required. Then the next stage is communication either with the assessee or with the technical unit or with the verification unit. These are all for specific purposes and functions. For the assessee to obtain any further information and documents or evidence from the assessee or any other person. The any other person would be any person having transactions with the assessee for cross-verification purposes. For reference to the communication with the technical unit would be for determination of arm's length price or valuation of property or withdrawal of registration, approval, exemptions, or any other technical matter. For the verification unit, again, all these people may again submit the information to the NFAC, and the NFAC would communicate the materials gathered and the information gathered to the assessment unit. And for, again, the assessment unit would send the proposal where it proposes to make any variation, or it is accepting the income or loss determined to NFAC, which whatever show cause is there, it is forwarded to the assessee, and the assessee would submit the response within the date specified, and that is forwarded to the assessment unit. And the next thing is after considering the reply to the show cause notice, the final proposal is prepared, and then it is sent by the assessment unit to the NFAC, and the NFAC may assign it for review if required, or convey the prepare the draft assessment order to the assessment unit. Where it conveys to prepare the draft assessment order to the assessment unit, the draft assessment order is prepared and sent by the assessment unit to the NFAC, and the NFAC would prepare a review again and forward the same through the NFAC to the assessment unit, and which gets forwarded as a draft assessment order to the assessee. And when the NFAC goes through the draft assessment order, it may grant permission to prepare the final assessment order, and the final assessment order, along with notices for initiating penalty, is sent to the NFAC, through which it is communicated to the assessee other than eligible assessees, along with the demand notice and the computation. Wherever there is a eligible assessee, the eligible assessee is cases which can go to the DRP. So wherever there is a transfer pricing adjustment, it would have this situation, because the other cases which can go to the DRP are foreign companies and non-residents, which are taxed, which are assessed by the international tax units, and they are not part of the faceless process. So here, from the stage of 15 in the earlier previous slide, we'll have to take it forward from that situation, that it would send the proposal for review unit would send the proposal to the assessment unit, or convey to prepare the draft assessment order. Then the draft assessment, the review report is prepared and forwarded to NFAC, which forwards it to the assessment unit. Then the draft assessment order is prepared and sent to NFAC, and the draft assessment order is sent to the eligible assessee. In case of any variation, he is given 30 days time to file objections or to go before the DRP, or file wherever he files an acceptance of the variation proposed, it goes to the NFAC, and the NFAC again sends it to the assessment unit, and again the assessment unit would prepare the draft, the final order, and send it through the NFAC to the eligible assessee along with the penalty notice. The demand notice would be added by the NFAC and sent to the eligible assessee. This is the whole flow of events that is envisaged in this faceless process. Now, we will see what happens in most of these cases where what kind of problems that can occur. See, as you know, in the login, when you log into the income tax portal by providing PAN and the password, you get into this screen, and when you click the e-proceeding menu, you have this drop down which is available. So you will have to select the appropriate drop down menu in the e-proceeding, and wherever the e-proceeding is there, you will have to say view notices, and then wherever the notices are there, after going through the notice, you prepare whatever your responses are. Then you click the drop down menu of submit response, and if you want an adjournment, that is also there, seek or view adjournment. So the user-friendly kind of design is there, done in the portal, and wherever you submit, click on the submit, then you get this following screen for attaching the documents, and you will have to attach the document, and then click continue for attaching the documents. Whether it is a partial response or a full response is also one of the points which you have to click, and then there is a small box here which you can fill, or you can just say please refer attachment, and then go to the this is what you will this is an enlarged version of the previous screen, and you select either partial response or full response, and thereafter the response can be either typed here. Mostly you should click the attachment, because the space given here, it can only take in 4,000 characters, which may not be enough for either a partial or a full response. So this is a mandatory field. So thereafter you select what is the kind of documents which you are attaching. There is a detailed classification of various documents. You'll have to click and tick whatever is applicable. And if you are attaching any further documents, you'll have to click the others, which is last, and just add for each document. The only problem with this is you can have only 10 attachments and not more than 10 attachments. So after uploading all the documents, click continue, and there's a self-declaration box. You'll have to check the same and say submit to file the response. Then a mail acknowledging submission will be sent to your registered email ID. And wherever you require this video conferencing, I would suggest in all or most of the cases, wherever you have received a show cause for making an addition, it is advised that the video conferencing facility may be availed, because in any proceeding, words expressed or stated can always make more or easier understanding than what you state in the letters or the submissions. So in case of any clarifications also, you can clarify orally in the video conferencing facility. Though the officer would be masked, he may not be showing his face. In many cases, you'll be talking to only an empty screen, but still it is advisable to seek video conferencing. And the practical aspects is it is suggested to ensure a complete reply in all the aspects that are raised in the query in the notices. And wherever a legal objection has to be taken, the legal objection has to be also made out very elaborately without any ambiguity in the interpretation, and whatever the decisions you are relying on also have to be stated, because since we operate through a high court system, there are cases where jurisdictional high court may be very favorable on a specific point, and the person sitting and completing the assessment in a different jurisdiction may have a different view taken by his jurisdictional high court. But the advisory given to the officers is to go by the jurisdictional high court decision wherever applicable to the assessee's jurisdiction, wherever he is located, not where the officer is located. So, because this happens mostly in cases where, for example, we in the past, before the Supreme Court decided the PF and ESI issue in the case of checkmate services, we had most of the high courts, excepting Gujarat and Kerala High Court, deciding in assessee's favor, and Gujarat and Kerala High Court had decided in department's favor. So when these kind of conflicts are there, and before the Supreme Court gives its final word, the legal objections also state that it is the jurisdictional high court decision applicable to your jurisdiction, and that has to be followed irrespective of whether there is any other high court decision also. So this is quite important in making the submissions, because if it is not properly addressed, the officer sitting in the other side may follow the decision of his state, which may be detrimental to the assessee, and matters have to be carried out to the next level of appeal. And if there is any third-party material or information relied on by the department, the copies of that should be asked for, and wherever required, you will have to request for a opportunity of cross-examining the person if the third party's confirmation or information is not in accordance with your claims. So this is also a must, because at the first stage, that is the assessment stage, is the stage where you get the luxury of time and the elaborate process being carried out. As and when it goes to the next levels of appeals, the time is also reduced, and these kind of opportunity to cross-examine or wherever third-party statements are relied, if a person does not ask for the copy or opportunity of cross-examination, then they miss the bus. So this is also one of an important aspect that has to be kept in mind wherever the show cause notices contain third-party reliance on third-party information or material. This is because this entire faceless system is based on artificial intelligence and data collected from various sources. I would narrate real-life incidents on how important this is, because now we have something what is called an insight portal, wherein most of the government agencies where it is required for a linkage between the PAN and their department's information. For example, if you are registering a property with the sub-registrar office, a PAN is required. So the sub-registrar would upload the data with the PAN in the what is called the annual information report. Similarly, wherever exports are happening, the customs department uploads the information based on the IE code linked with the PAN. Similarly, imports also, the customs department uploads IE code with the PAN, and various mutual fund transactions or stock market transactions again are reported by various agencies based on the PAN. So what happens is all these information, apart from your 26 AS and the tax information statement, all these are compiled based on the PAN and is dumped on the assessing officer in the assessment unit, where this faceless assessment is allotted. So he can, based on this information, he can call for further information saying that he has got information that you have exported X quantity. Similarly, the GST turnover and the GST paid is also shared in the income tax portal. So what happens is typically in a case of a builder, the method of recognizing the taxable turnover for the purposes of GST is different from that what is being adopted for income tax purposes. Because as and when advance is received, you will have to pay GST. So it would be turnover for the purpose of GST. But it need not be the same for a builder for the income basis. So all these are third-party information where that would be asked. It may be the information which the assessee himself has uploaded through the GST returns. But still, if there is any reliance made based on third-party information or other material, it is a must to ask for that. And wherever statement is recorded, where a third party makes a claim that he has paid the taxpayer X amount, which is in or he gives a statement of account and the closing balances do not match. So in these kind of cases, you will have to ask for the copy of the material led by the assessment unit, and wherever required, also ask for cross-examination. We can file a reconciliation which is accepted, then it's good. But there are chances that the reconciliation may not be accepted. Again, the reply has to be made para-wise by dividing the submission into sub-paras so that it is easy for quoting and referencing for the submission. And also a detailed reference to the evidence like annexures are also required so that it becomes a complete document, so that the reference, if it is detailed as 1, 2, 3, and if the whole thing is numbered, page numbered, it becomes easy for person making the reference also not to miss it. And take care not to admit or confess an income or a fact that is adversarial if it is not in accordance with the transaction. Because if you make an admission, then it is, I would say, impossible to retract at a later point of time if it is based on any misunderstanding of a fact or misunderstanding of law. Only if you are very completely thorough that it is a mistake or it is an omission, then you make an admission. Otherwise, I would suggest it depends on facts of each and every case. It is not a one size fits all. So wherever you are making an admission, you take a complete 360-degree view of whether it is the right thing to do. And if it is the right thing to do, go ahead and do it. Then check if all notices have been issued and served properly within the replies to the notices and within the limited time. And the related provisions and judicial pronouncements is also, as I said earlier, take all the legal defense that is required and kindly avoid repetition because it would affect the coherence or the flow of the replies. Then the reply of the assessee must be filed from his registered email ID only, registered with the income tax department in the PAN, so that the same ID is used everywhere. It is also advisable to submit the reply within the time limit specified. If not, the window may get closed and an ex parte order may be passed. So wherever required, an adjournment letter within the time allowed should be filed for requesting for extension, and the timelines should be adhered. That is one of the disciplines that this entire faceless assessment scheme brings in. It brings in a discipline of adhering to timelines, so that there is no pressure on both the taxpayer or the department towards the fag end of the limitation. And it is advised that a covering letter be filed along with each submission. And in the typing box, it is advised to write the, as I said, giving the letter format and reference to the notice and the covering letter, so that when you when you click the attachment, it is known that you are attaching the reply and the letter format for the notice which is being replied to. And in case of a full response submission, it is advisable to reply to each and every point in the notice. In case any requirement is not applicable, the same can be mentioned as not applicable in the response. The attachment name should not contain any special character or space, so that has to be kept in mind, because the system doesn't accept and it doesn't get uploaded. The attachment shall be in PDF or Excel, or and the maximum size of the attachment shall not be more than 10 MB for each time. So this is the size limitation for the attachments. So you'll have that in mind, and if it is more than 10 MB, it is advised that you break it into less than 10 MB, so that you can say part 1, part 2, and make the attachments. So maximum of 10 attachments is permitted for one submission. If there are more than 10 attachments, you can submit through the same link again, and say part 1 and part 2, some kind of distinction being made. So it is also advised to make a system wherein on alternate days you check the e-proceeding portal if there is any notice issued by the department. Because since we are going through a changeover phase or an evolving system, there may be chances where you don't get an SMS alert, but it is uploaded in the portal. So it is always advisable that wherever now the number of cases that are taken for scrutiny is reduced drastically, and it is also selected only through an artificial intelligence algorithm. So the list of the assessees whose assessments are taken up by the faceless assessment scheme may be kept, and every alternate day you check on the e-proceeding portal whether there is any notice issued, so that you can keep a tab on what is happening and you don't miss out on the deadlines. But taxpayer fails to respond to a notice, there's a risk of the assessment being completed under 144. But the 144 proposal has to be sent. So because then what happens is when you don't reply and a 144 proposal is sent, then it becomes difficult for you to again take the assessment team to the by giving all your explanations, and again the process of the assessment unit going through your response and again preparing a draft assessment order is forced on the unit. So it is always better to avoid non-response. If at all you require, that is why I've been mentioning that you keep a tab on the portal, and also wherever you are not able to respond within the time specified, ask for further time. And the best judgment assessments, when it is passed, it causes a difficulty of making an appeal and also a deposit of 20%. So that is the problem which can be the outcome if the responses are not filed in time. Then a person is not required to appear personally or through authorized representative. So that is the intention of the entire scheme. And in case a variation is proposed by the assessment unit through the NFAC, the taxpayer will be given an opportunity to make submissions. And also you can request for the video conferencing, which was already dealt with in my submissions earlier. So the taxpayer or his authorized representative can also request for a personal hearing or make oral submissions before the authority in any unit under the scheme. And such hearing would be conducted exclusively through video conferencing. And there is a specific procedure that has been laid out. And the income tax authority has the power to examine a taxpayer and record statement through the video conferencing facility also. So this is also provided in the video conferencing facility. And there are suitable facilities that have been established for the officers to conduct the video conferencing at various locations around the countries where the regional faceless units are located. Then the internal communication also between the NFAC and various units are through electronic mode, and the taxpayer shall file his response to any notice through his email account, which I had earlier stated. And once an acknowledgement is sent by the NFAC containing the hash result generated upon successful submission, the response is deemed to be authenticated. So this is a process where as soon as you make a submission and the NFAC sends an acknowledgement, this record has to be preserved for future reference or requirement in case of any appellate proceedings. Because there are cases where the response has been submitted and the order has been passed without considering the responses in the past. And I don't hope that in the future this kind of a situation would arise, as quite a bit of corrective steps have been taken for non-consideration of the responses. So therefore, if you have made a response, the copy of the response and this acknowledgement has to be preserved. And every notice made which is served through the email account registered in the e-filing portal is deemed to be delivered, even whether you look at it or not. So this is why I had stated that every alternate day, just go through the portal and see whether you have received any notice. So because the department's onus of delivery is completed as soon as it is communicated to the email account, whether it goes into your spam or whether it goes into your primary folder in the email account is not the responsibility of the department. So you will have to look at the portal and also to your email and also to spam. And whenever you first notice is received, it is advisable to click on the email ID of the sender and add it to your safe sender list so that it doesn't go to the spam in the future. And uploading of the authenticated copy in the mobile app, Assess's mobile app, followed by real-time alert to the taxpayer. So whenever a notice is sent, it is also an alert is supposed to be sent, and there are cases where alerts are not sent to the officers, and therefore they have missed out on the notices. So, but still, if it is communicated to the email account, it is deemed to be complete. So the next part is on why the registered email ID is important, because of various authorities sending the data to the through the Insight portal. What happens is that I'm talking about a real-time case where a firm got converted into a sole proprietary, and the registered email ID of the firm was different to the registered email ID of the sole proprietor. So what had happened was, after the firm has been dissolved and continued as a sole proprietor, they did not look at the email ID of the firm at all. And basically there were exporters, and the export data of the firm was uploaded in by the customs department, which came to the income tax department. And since they found that the firm had not filed returns because it got converted into a sole proprietary, and the entire export turnover had been offered in the hands of the sole proprietor, they did not know the existence or the receipt of the reopening notice and the subsequent notices in the email account attached to the firm's PAN. So therefore, it finally ended up in an ex parte order, and the difficulty of going through the appellate or revisionary process is thrust on the taxpayer, which is entirely avoidable if he had been diligent in looking at, because the Act gives powers to reopen the past years. So till that time is available, wherever there is a change, like in this constitution, like a firm to a sole proprietor, or it is ideal to continue with the email ID or look at the email ID of the erstwhile entity as well. So now the scheme has developed that in case where there is no response at all in the notices, one notice is in physical form is sent to the address of the assessee as is registered. So that is the only physical copy which would be sent. And if that is also not properly addressed by the taxpayer, then he will have to go through the difficulty of facing a huge demand, completion of assessment and ex parte, and a huge demand, and seek appellate remedy. So in the video conferencing, it is these are the normal code which all of us are already accustomed to, of introducing ourselves before we talk and ensuring that the microphone is not in mute, and also aware of the video settings. All these because we have been attending quite a bit of webinars and video conferencing during the pandemic time. So we are clearly accustomed to these kinds of do's. And the don'ts is that this also we are quite clear on. Only thing is we will have to carry out the entire hearings where you don't have network issues, because if the video conferencing is not happening in the scheduled time, to get another schedule is again a cumbersome process, and ensure that you don't have any network issues from the place where you are conducting the video conferencing. This is a basic chart which differentiates between e-proceedings and faceless. In the e-proceedings is the earlier avatar where you know the assessing officer, which is who is the jurisdictional assessing officer. This is completely faceless and nameless. And applicability is there are more or less they are same. Only the assessing officer would be faceless, and it is governed by the NFAC and the units. And time limits for reply are all specified in the notices. The assignment of cases to by the NFAC in the faceless scheme, and the enquiries are also done through the electronic mode. Here, the questionnaires, those sent by electronic mode, you can also go and participate before the officer in the erstwhile scheme, because you know who the officer is, and for any clarifications, the officer may also contact you for asking for further information. So all these are not possible in the present faceless assessment scheme. And as I said, it is only through video conferencing is the only interface where you have for your face, and even then the officer may not show his face, but all other proceedings would be conducted in the electronic mode only. So the basic 144, old 144B and the amended 144B is also there. In the amended 144B, you have a reference to 142(2)A, which can be recorded, and a special audit can be ordered in cases which requires in-depth audit by a chartered accountant, and for which the permission has to be obtained from the principal chief commissioner or the CC. So the power to transfer cases is one more aspect that is in the new 144B, sorry. And the authorities have the power to direct the AO to invoke 142(2)A special audit. And these are the basic differences. Apart from that, the benefits and of the faceless is that the entire proceedings can be done from your office or home, wherever you find it convenient to comply with the notices. So, say for example, in the earlier scheme, where the assessing officers are located in different parts of the country, you will have to travel to them and submit the details. So that kind of travel time and interface is removed, so that you also, like the assessing officer, can conduct your proceedings to reply at the convenience of your room. And the transparency and efficiency and uniformity is achieved by the department. The quality of assessment is improved because of the functional units having the domain expertise. And as I said, it saves time and money for the assessees and the authorized representatives, and cost effective for the government, and also the harassments can be reduced or avoided. And the assessment will be done by a collective mind of the entire unit. And the chartered accountants not using electronic means face difficulties, not used to, I would say, not using, I would not say, because uploading of voluminous documents is the only, I would not say drawback, it's the only issue that is being faced by the chartered accountants in the faceless assessment, and difficulty to explain the subject entirely in writing is also an issue that is being faced by the chartered accountants. And again, from the department's perspective, the officers make conclusions based on their understanding of the subject. So this is also an issue which I think would be addressed as the faceless scheme evolves over a period of time. There are technical glitches either in the submission or in various aspects which have an impact in the faceless assessment scheme, from either from the mostly on the portal. If it is slow, it delays the submission process. And I think over the period of 2 years, this has been addressed to some extent And now you are able to upload documents, though I would not say it is working in a magnificent speed, but still it is improved over a period of time. And the size of file, that is one issue, which is because it's to be broken down in the size of 10 MB. So that is one of the issues, I think, which also will get addressed in the future. And 10 documents per submission. So what happens is you will have to keep on uploading if you have more than 10 documents. So again, you will have to do it once, the whole process. Either if you do 10 at a time, you will have to do 2 or 3 times, which otherwise, if it is enabled to take a larger file size, I think which will happen in the future. And except for providing a copy of draft assessment order, there's no provision for providing a copy of the draft assessment before completing the assessment proceedings. So the show cause is the only point at which you would know what is the proposed variation or additions that are being made. And opportunity of the of being heard is provided to avail the video conferencing facility, and no other opportunity is provided to the assessee. So these are the basic things. Apart from that, there are some non-alignment in the drafting. I think this will get addressed in the future, because in case, say, subsection 6(7) says that in case where there is a variation proposed, an opportunity of being heard is provided to the assessee by serving a show cause notice. The assessee or authorized representative may request also for personal hearing. But whereas in provisions of 144(b)(1), which defines the procedure, states that in case where there is a variation prejudicial to the assessee, the no provision for providing a draft assessment is not there. So we'll have to see whether these two are going to be aligned in the future or not. So there are various references to the provisions, and in the future, the whole scheme of not just assessments, it has now been extended to appeals. And in the future, we are also looking at faceless revision of orders and faceless giving effect of orders. So all these would enable effective, transparent, and efficient administration of the entire faceless scheme. Now, the practical problems which the scheme, original scheme, which, because since I was saying that this is an evolving scheme, so there are short time that is given to respond to a notice. So in the case of Urdu Education Society, the Bombay High Court held that where the assessee was given 4 days time to respond to a show cause cum draft assessment order, which included 2 holidays, it was set aside and remanded to be decided afresh. So basically, since this is a self-contained code for the entire process, one of the aspects is opportunity of being effective opportunity of being heard, I would put it like that, because you will have to be given enough time to respond to a show cause notice. It cannot be a mere pretense of giving an opportunity. So in the case of Ramco Cements, the Madras High Court held that where it was an order of penalty that was passed, and the assessee's request for personal hearing was not at all decided, because previously the personal hearing in most of the cases were not given. Now the portal itself enables, and you will have to click that option to, if you want to enforce or avail the personal hearing. As I said, there can be 2 or 3 kinds of litigation, because it is in the evolving stage. One, as I said, the time. Second one is lack of opportunity in the form of the video conferencing facility. Third is without an addition made without show cause notice or without a draft assessment order, or where a show cause notice proposes an addition for which you reply and that addition is dropped and some other addition is made for which no show cause notice was issued by the faceless assessment officer. So these are the kinds of cases where, again, it also boils down to lack of opportunity because you are not given a show cause notice of what is going to be the variation. Again, in these cases also, the matters are going back to the assessing officer to be done in accordance with the law by giving an opportunity. This is again the Gujarat High Court, which held that the assessment order was passed without a draft assessment order along with show cause notice. It is to be set aside to be redone again. So most of these cases would go back to the assessing officer again. So this is one of the important decisions of the Delhi High Court in the case of GPL, RKT, CPL, JV, wherein it was held that the assessment order was passed by assessing officer located in Bilaspur, Chhattisgarh, and the doctrine of forum non-convenience, that is there. So the assessee filed a writ petition before the Delhi High Court challenging the officer's order that the Delhi High Court refused to entertain the petition, and it would be appropriate to refer the matter to a larger bench for conclusive view because this would apply to various cases in the future. And again, this retrospective amendment of 144B9, since it is removed, so most of these decisions are only for academic interest, because if it is, the earlier provision said if it is not in accordance with the procedure of 144B, the order becomes void. So the omission of 144B9 and various other checks and balances provided in the procedure, these decisions have only academic interest. And in this case of Rajasthan High Court, the matter was remanded back to the assessing officer, where the assessing officer completed the assessment under section 143.3 and thereafter issued notice under 148 to reopen. And since the assessee did not reply to notice, the assessing officer issued a final notice under 144. And the assessee filed a reply to such notice within the time permitted. Despite this, assessment which was carried out to the faceless assessment scheme did not acknowledge the reply. So that is what I had earlier stated. The acknowledgement of that reply is quite important. And this assessment was again sent back to the assessing officer to decide afresh after considering the assessee's reply. So these are the kind of litigation that is coming into this faceless evolving scheme. And going forward, the points on various aspects like the time and time for response for the notice and the process of having a show cause notice, these have all been properly addressed. And there could be cases where I had said on the jurisdictional high court vis-a-vis the high court of the place where the officer is located. So that also has to be addressed in the submissions so that you avoid that kind of situation as well. So friends, this is what the present problems or difficulties which are faced, which effectively by a dynamic role played by representatives like us can resolve most of these issues if the notices are responded within the time, and the basic checks and balances of verifying whether the correct email ID is there in the portal, and frequently looking at the verifying with the portal whether there are any further notices. If there are any specific questions, I would like to take on the questions because the practical aspects would be, or the difficulties which you face would be more known to you, rather on a bird's eye view of what I have presented in the last 1 hour. So I would like to take questions if
Dear participants, if you have any doubts regarding this practical issues on faceless assessment, you can text in the chat box so that speaker will address your queries.
there is one question on adjournments. How many times adjournments can be requested?
Yes.
I think the question is raised by
Bhushan Ramani.
Bhushan Ramani. Sir, you can ask adjournments once, twice, but more than they are quite reasonable at the initial stages of the notices when you ask for adjournment. But if the data that is required to be furnished can be furnished in partial response, I would suggest that would be a better option than to hold back the entire response for the matters for which you require additional time. So initially 2 to 3 adjournments are liberally granted, but it adds pressure on both the representative and the officer, because you would be pushing everything towards the time limits, because everybody has to go through a time limit in this system. It is not like the physical system where you can also go and furnish the data on the last day. Here, because the information has to be processed by the review unit and it has to go through the National Faceless Assessment Center, the timelines are quite important. And yes, they are liberal in the beginning, but that doesn't become a norm. And it depends on the number of items of information asked in the notice and how many you have complied and for which you want further time. Again, a further query. Further, if we file partial response, whether we get any response from NFAC or do we need to file full response or get response from AU? As I suggested, you have the portal, you have an option of filing partial response. And in the box there, you can say or in the covering letter, which is going along with the partial response, you specify that you have responded to the various points and you require further time. And automatically the NFAC, upon your successful submission of the partial response, would generate an acknowledgement, which would be the, I would say, the acknowledgement for you filing the partial response. Regarding the time, you may get, because you would be asking for 10 days more or 20 days more, first, because that is from your side. And if there is any variation, you will get a response from the AU unit saying that you are given time up to this. And if there is no communication received, you can deemed acceptance of your request of, say, 14 days or 15 days, whatever you have asked in your letter. That would be the deemed acceptance for that extended time. And you will have to comply by filing the balance details within the time.
There is one more doubt, sir.
Yes.
Sir, if manual assessment is done under section 142(1), and order has given by jurisdictional officer, still e-assessment can be initiated by the department.
So what happens is the power in case of non-response. So these are some of the cases again. What is called the examples of the faceless assessment scheme not properly working is there are information that are uploaded by the sub-registrar office, and this is an example where about 50 properties were registered by a builder on one particular day, which included one non-resident as well, who is not a income tax assessee. And for registering a property, you can give your Aadhaar number, or if you don't have a PAN, or give a PAN. What happened is when they uploaded all the 50 properties against one name instead of giving all the 50 names. So his assessment was reopened, and since he was a non-resident and whatever notices were unanswered, the demand was created at the end of the process. So some of these kind of cases where there is no PAN are transferred from the faceless to the jurisdictional assessing officer, where the assessing officer tries to reach out by sending physical notices and also the show cause, so that the process is complete. So these are the cases where the assessments are transferred from the faceless to the physical officers, where there is no response. That is the main criterion. But if you are having an assessment that is already completed and you have a reopening notice, you will have to understand what is the reasons recorded for reopening, and to also look at whether it is coming out of a change of opinion or it is on some other ground, and address that reopening separately. Because the reopening, again, the new amended provisions is again a self-contained code where you get a time of 7 days to respond the show cause notice, and after that an order for reopening the assessment is passed, giving effect to that Supreme Court decision in the case of GK and Drive Shops. They brought it as a procedure before issuing the notice.
There is one more question, sir. We have replied on 9th November 2022. No communication from AO. Is there any ways to connect the AO through email?
There is no way to connect to the AO, sir. All you have to do is, if you have made your submissions, and you have to wait for them to send. That is why you will have to look at the portal every alternate day to see whether there is any other submission requiring us any further submission or any further notice is issued. You will have to check with the portal, and you will have to also see what is the due date for completion of the assessment also. So most of these assessments are completed only in the last month, where the time limit is expiring.
One more query, sir. Is there chance on an enablement by CBDT for filing Form 3 to get Form 4 from the department under IDS 2016 scheme?
See, this IDS 2016 is an entirely, which I think 30th September 2016 was the date of closure of that scheme, and the time limit to make payment was granted, I think, to March or such extended period till 2017. And once you have made the payment, you will have to approach the principal commissioner having jurisdiction over the case. If you have not filed the form, if Form 4 is not obtained, you will have to address it to the PCIT having jurisdiction, so that the process is completed if you have made the payment of tax within the time stipulated under the IDS 2016. Otherwise, because this is not covered by this Faceless scheme, the IDS again, if the time limit has lapsed, the CBDT is the authority to enable. You may try raising a petition under 119(2)(b) wherever, depends on the facts, to the CBDT or to the Chief Commissioner. Or first ascertain why the Form 4 could not be received from the department, from the PCAT's office.
I think no more questions, sir, from participants. Thank you, sir, for your elaborated presentation with the excellent explanation. I hope every participant who attended here enriched their knowledge with your presentation, sir. Thank you.
I think there's
One
one
more
last
question
query.
from the member.
One more question, sir.
One more question. I'll just take this. Sir, received notice under 148A on surrendered PAN. So actually you will have to give all the facts on why the PAN, because whether it's a case of a duplicate PAN or whether the associate has been dissolved. So those facts have to be furnished in response to the 148A received. And if the order is passed under 148AD, you will have to accepting your contentions, then well and good. If not, I would suggest you take it before the High Court on a writ. I think Mr. Subramaniam said, can I ask one? Please go ahead, sir.
Sir, good evening, sir.
Good evening, sir.
Sir, I have one. I already mentioned in the chat box. There is IDS scheme 2. My client paid already the taxes all within the timeline, sir. But
Okay.
non-submission form 3, non-response notice. So these people have completed the assessment under section 144. And they have given me the liability around 1 crore. For that, we filed form 35.
Okay. But you have made the payment for IDS within the time, sir?
Within the time, sir. Within the time, but after filing that, form 3 is not filed. Form 3, where I have made the payment, the declaration was not made.
I would suggest you file a petition under 119(2)(b) to the CBDT requesting to enable the form 3, enable you to file form 3 and get form 4 so that the process can be completed. And in the meantime, keep the appeal in abeyance. If CBDT is not acceding to your request, you will be successful in a writ before the High Court.
Now the appeal is in progress, sir. Appeal is in progress. In addition, I can file 119(2)(b) also.
119(2)(b) is independent, sir. 119(2)(b) is for the IDS.
Okay.
It is not against your demand.
Okay. Thank you very much, sir. Thank you so much.
Questions from the members?
Hello.
Sir, it is audible, sir. Please go ahead.
Yes, sir. Sir, with respect to the question put in the chat box, supposingly I have filed a partial response to a notice. So whether I will receive any communication from NFC or AU, or first I have to file the full response and then I will receive any communication with respect to further discussion or two-way communication from the AU.
Unless you complete the submissions, you may not get a communication on further queries.
Okay. So on partial response, we are not receiving any queries or discussion.
You will not receive any supplementary queries on a partial response because once your response is complete, only the faceless officer goes through the proceedings
Okay,
for
sir.
further queries or considering your reply.
Okay, sir. Sir, one more query was there. In the case where you said that if we are unable to respond or the SS is unable to respond to the 142.1 notice or any notice, and the proposal for 144 assessment order is passed, a draft order.
Yeah.
So we have to defend that 144 order because that will be done at the end of the assessment at the.
No, you will receive a show cause saying that this is going to be my order under 144. So
Yeah.
immediately you will have to respond, because there will be a time specified in the show cause notice itself as to why I should not complete the assessment under 144.
Yeah, but
Immediately you respond with all the data that is called for in the original notices.
okay, fine. So actually the 144 draft assessment will be at the completion of assessment or deadline last 15 or 20 days.
Completion. Draft would be asking you to show cause why I should not complete it ex parte as under.
Okay. Yeah, but it will be received in the end of the month only, na?
No, it will be received at least 10 or 15 days before.
Okay, sir. Okay, thank you so much.
Other members can unmute yourself and can speak. One more question. Video conferencing can be done in our PC?
Yeah, you can do it even through your phone. It doesn't require a PC at all. If you have a smartphone, you can do it through your phone also. But if you have some presentations to be made, or you want to share your screen, all those things, it would be advisable to do it from your office desktop than doing it from mobile. Because they have a specific utility called Divya Darshani or something like that. Divya. So that is the platform which they use for the video conferencing, and they send the link also to the email ID. So you can use it wherever you want. You don't have to even have the download the app.
Please come to.
Thank you, sir, once again for doubts clarification also. Dear participants, thank you for attending today's session, and I request all of you to attend for tomorrow's session at 6 p.m. on practical issues on faceless appeals by same speaker Ramakrishnan sir.
ఎవరు అడిగినా క్వశ్చన్ అడుగుతాను కదా నోటీస్ సొసైటీ డైరెక్ట్లీ హైకోర్టు వాళ్ళకి ఫస్ట్ చెప్పేదంటే ఫైల్ రెడ్ పిటిషన్ అట్ హైకోర్టు వాళ్ళు ఏడు సస్తా ఇప్పుడు ఒక రిజైన్ చేసి
Kindly mute yourself, please. Okay, sir. Please go ahead.
Thank you, sir.
Thank you, sir. Thank you.
With this signing off.
Okay.